Welcome, everybody. Tonight, we are joined by a very special guest who expertly and successfully displays her skills in persuasive communication in the field of law. Erin Gallagher Barnhart received her bachelor's degree in interpersonal communication and a master's degree in rhetoric and public address from Ohio University in 2002. 3 years later, she earned her Juris Doctorate at the University of Notre Dame Law School, where she received the Faribault Prize for High Scholarship in Law upon graduation and was recognized as one of the top 3 students in her class. While in law school, Erin served on the Law Review, a legal academic journal, and published a student scholarship note about fair use in copyright law. She is currently an assistant federal public defender for the Southern District of Ohio's Capitol Habeas Unit, where she represents death row inmates in federal habeas, civil rights litigation, and state clemency matters. Erin also serves as the co-coordinator of the externship program. In 2018, Erin's client, Raymond Tibbins' death sentence was commuted by Governor Kasich due to an unfair trial hearing. An early access podcast about Erin's current client, Elwood Jones, who is trying to prove his innocence, is now available, and the subscription information will be in the chat below. Her work isn't always so serious, though. At OU, Erin's honors thesis tutorial explored why adults like to indulge in children's series, specifically the Harry Potter series. We are so eager to hear about Erin's journey through law and how she incorporates her skills in persuasive communication, owned as a member of the Ohio Forensics and Debate Team, to excel in law school and now to advocate for her death row clients. Please welcome Erin Gallagher Barnhart.
Thank you so much, Amy. I'm really excited to be here. A bit delayed, but that's all right. As I've been teaching my daughter during the pandemic, we have to learn to be flexible when situations are unexpected. So I'm glad to make it tonight. Like Lynn said, I could talk about my work like for a month and I still would have more to say. So I sort of distilled it down into maybe 3 areas that I thought I would share with you all to give you a sense of what it is that I do, and but I'm very interested in answering questions or sharing stories that people would want to hear. So what I do is called federal habeas. Some people have heard of like the writ of habeas corpus in the Constitution. Most lawyers don't even know what it is that I do though. So this is like a chart that I use to teach our law student externs about our work. And by the time I walk through this, like everyone's brains are bleeding out of their ears. So it's a very technical, specialized area of the law, but at the same time, it's incredibly meaningful because I'm representing individual people who are in prison and facing execution. So I get involved sort of like halfway through the process. My clients are all convicted in state court in Ohio, and they have a series of appeals in state court. Only when that's all done can my office get involved filing in federal court a habeas petition. And for a variety of reasons, court decisions and in particular a law passed in sort of the heyday of criminal harsh sentences and those kinds of reforms, it's nearly impossible to succeed in court. In fact, my office has been open for, I think, 13 years now. And in all that time, we have a single court victory that withstood all of its appeals. And I currently have a case at the Supreme Court, which, if the Supreme Court does not reverse it, will then be our second only win in court. It's designed to be really difficult, but we sometimes like to say that we win by losing and redefine wins. So there's a lot of different creative things that we do and other ways that we succeed, even if it sort of seems like on paper we have not. So anyway, the thing that I think more than anything surprised me about this work is how many innocent clients I have. I was just shocked and devastated to find out how poor investigations are. Now, my clients, by the time they get to me, their cases are older. So I'm dealing with cases from the 90s, 2000s era. Some, before DNA testing, some after. But The amount of cognitive bias that I see in cases where there's tunnel vision, investigators sort of drop other leads and other suspects once they zero in on my client is really disturbing. And then 20 years later, it's very hard for me to do anything about it because witnesses are dead and crime scenes don't exist anymore. So that's a really frustrating part of my work. The other thing that's crazy about it is that this law I mentioned from 1996, which is the Anti-Terrorism and Effective Death Penalty Act, or AEDPA, or EDPA as we call it, requires that any claim that I bring in my client's case in federal court be based on a constitutional right that the US Supreme Court has clearly established. And that really narrows the category of claims because the Supreme Court hears only 50 to 100 cases a year, and that already is limiting the pool. But here's the thing I think shocks most people is that our Supreme Court has never clearly established that it's unconstitutional to execute an innocent person. So right off the bat, I'm technically not even allowed to try and seek relief for a factually innocent client in our court system the way that it's set up. And so this is where the creativity comes in. Instead, I am often pursuing a claim that trial counsel didn't perform properly under the Sixth Amendment because they didn't present the evidence that could have proved my client's innocence. And then there's a variety of other complicated things that can happen back in state court or through other proceedings. But that's definitely the hardest part of my job, is explaining to my clients who are innocent why I can't do most of the things that they want me to do and make most of the arguments that they want me to make. So the first clip is about my client, Elwood Jones, who is the feature of season 4 of the Accused podcast, which is now publicly available. The first 3 episodes are out, on iTunes and wherever else that you would get your podcasts. There's a total of 7 so far, although we are supposed to have a hearing starting in 2 weeks where we're presenting evidence to try and get my client a new trial based on his innocence. And so the reporter is going to be continuing to do more episodes based on what develops in our case. So this clip was, this was several years ago because this new trial hearing was supposed to start the first week of April in 2020. And obviously that didn't happen because of the pandemic. And my client has been waiting now for nearly 2 years to get his day in court that he was promised. He's been there 27 years total. So it's a very tough case. So if you want to play that, Lynn, and then I can talk about it.
You bet. And when I start this, please let me know. Someone can just say, yes, I can hear and see this. Y'all see it?
You can see it.
His lawyer says there's new evidence that warrants a new trial. A woman who was in the Hamilton County Jail years ago came forward and said another man killed Nathan.
And another woman in the jail, whose name was Linda Reed, confided in her that her husband, whose name was Earl Reed, had confessed to doing the murder in the embassy suite and framing a black man for it.
Both Linda Reed and her husband are now dead, leaving only the statements of the woman who was in jail with Reed. During the trial, police also said they found Nathan's pendant in Jones's car.
I don't think the police and prosecutors were convinced by the pendant because even after they found this pendant, they didn't do anything to arrest or prosecute Elwood for more than a year.
Barnhart says prosecutors used what she calls junk science to convict Jones. Jones had an infected hand injury that prosecutors say he got by hitting Nathan in the mouth. But Barnhart says it was a cut.
Thanks. So that's a really interesting case. If you're into true crime, I think you'll really enjoy the podcast. The investigative reporter who does this is excellent. And I really recommend the first season of it as well, which is about a cold case murder from outside of Miami University in Oxford, which I think really resonated with me as someone who had a lot of friends attend Miami University. So that's the first kind of case, a new trial, innocence case, which technically I can't do because it's in state court. So I'm actually coordinating with some volunteer pro bono attorneys who are allowed to appear in state court to do that case. And may or may not have to testify myself actually at the trial, at the hearing, which is another reason why I can't be an attorney for it. So that's one type of case. And so then the second one is what Amy mentioned about my client Ray Tibbetts, who was granted clemency. And in a death penalty trial, unlike any other kind of criminal case, there's actually a whole second phase of the trial called the penalty phase. So most trials have a guilt or innocence or culpability phase. The jury decides if the defendant is guilty or not. In capital cases, once they decide that, and also in Ohio, if they decide the defendant meets certain what we call aggravating circumstances that are supposed to narrow down the class of cases that are eligible for capital punishment to the worst of the worst, it moves on to the penalty phase. And this is where we do what's called mitigation work. And so mitigation is not a legal excuse like self-defense or not guilty by reason of insanity or something like that. It is fully accepting responsibility for being guilty of the crime, but an argument for why this person does not deserve the ultimate punishment. They are not the worst of the worst. And I don't think I have, it's very rare to have a client, someone on death row, who themselves didn't suffer some kind of trauma in their development, even before their life. There's prenatal trauma. Some mental illness is multi-generational. The effects of substance abuse or physical abuse on a pregnant woman can have effects on people's development. So we basically try to find every single piece of paper that has our client's name on it. We talk to people that he went to school with, teachers, other people he knew or worked with. I'm saying he because all of our clients are men. There is one woman on Ohio's death row, but not my client doesn't represent her. And we're exploring things like intellectual disability, exposure to environmental toxins, brain damage, either organic or sustained. As I mentioned, different types of abuse and neglect. It's a whole spectrum of things that we're trying to understand our clients' lives. The prosecution wants to start the trial or the story of the trial the day of the murder and say, this guy killed somebody. But we want to expand the story to start the day he was born, or maybe the day his mother was born. Like we're going way back and we're providing the context for how somebody could have ended up in the situation where they really saw their options as much more limited than we would. We being people who, have functioning executive, frontal lobes, executive functioning skills, who understand how to de-escalate things. And I mean, we work with amazing experts who can literally show you changes in a developing child's brain based on, not receiving adequate love and nourishment and support. And the expert that we had for Mr. Tibbetts liked to say, what wires together fires together. And so in his youth, which was, he was extremely neglected and then later abused, he's, his brain, his neurons are forming these connections, and other parts of his brain like literally like prune off and don't develop. Mr. Tibbetts also, and like many of our clients, they don't receive appropriate treatment, and so they self-medicate with drugs or alcohol. And the really sad thing about my client is that he had managed to get himself clean and sober. He had a job. He was working down on the river in Cincinnati, and he was injured on his job. And in treating his injury, he was prescribed opioids to deal with his pain, which of course now we know is just setting someone up for failure. And you can draw a straight line from when he got injured, started taking the opioids, became depressed because he wasn't able to earn for his family anymore, started turning back to this path of abusive substances. And the woman he killed, they had a history of kind of violence and unhealthy behaviors together. So it's the kind of thing where you're not saying like, oh, he doesn't deserve, punishment for this, but you can just sort of understand like, he almost didn't have a chance. Like, from day one, he didn't get the nourishment and love and attention that he needed. He was shipped to different foster cares where there was horrific abuse. He's running away from them. This is back in like the 50s. And so they just put him back in these same places he's running away from. Nobody's interviewing the kids separately and being like, oh, do you feel safe and everything? The parents are right there and they're pressuring the kids to, say that they're fine, when in reality, they're being tied to the beds at night and given dog food to eat and just really, really horrific stuff. So that's the kind of thing that attorneys are supposed to explain to juries in the mitigation phase of trial, just understanding our client's life. And in Mr. Tibbets's case, that didn't happen. His attorneys could have done this and they just didn't do their job. And when we were on the case and before we were on their case, throughout the appeals, his subsequent lawyers raised this as a claim that his lawyers at trial didn't perform up to the constitutional standards. But like I said, it's intentionally really difficult to win these claims in court. And so all the judges recognized like, yeah, they should have done better, but, and this is where we always get hung up, we're not sure it would have made a difference. Like the jury might still have sentenced him to death anyway. And so we can't give you relief in court. So anyway, we then were doing something that comes at the end of my role with the client, which is Clemency Proceedings. And that's before Ohio's parole board, and the parole board gives a non-binding recommendation to the governor. And we presented our case for clemency. At the time, I forget how many people were on the board, but we only got one vote in favor of clemency. And then because of some serendipity about something totally different that will be my third topic area, my client's execution date got pushed back. And it got pushed back. It ended up getting moved back over a year. And in that time, a juror from his original trial stumbled upon the materials that we presented to the parole board at clemency when he was just sort of like, Googling to see what's going. Actually, he saw an article about one of my other clients having to do with our lethal injection litigation. And that sort of reminded him like, oh, I wonder what's going on in that trial I sat on 20 years ago. And he found it. And he said, like, as soon as I saw these documents, I knew I wouldn't have recommended a death sentence if I had seen these at trial, because the attorneys tried to say he had a tough childhood, but the prosecutors were like, no, like moving to the foster home was the best thing that ever happened to him. And this juror said, I didn't know, how to know which was correct. And importantly, in Ohio, if a single juror does not want to recommend death, then a death sentence is off the table and the defendant has to be sentenced for life. So he wrote us an email that I sincerely doubted the authenticity of when I first read it, but I went and met with him, and he's extremely sincere and genuine. And he wrote a letter to Governor Kasich, who ended up deciding to stay our client's execution just days before it, and then sent us back to the parole board for a second hearing so they could hear from the juror. And now they would have the answer, like, would it have made a difference? Well, we know it would have made a difference. This juror says so. So this clip is just a little story about our presentation at the parole board. And for a short time, you'll see me and the juror, whose name is Ross, sitting at a table, I think it's on the right side of the screen. And that's us presenting to the parole board. I don't hear the volume.
Can you all hear that?
I could not.
Okay.
Yeah, we can see it, but we can't hear it.
All right. I'm going to start it over.
New at noon, a convicted killer initially sentenced
hear
to
it now.
die will now spend the rest of his life in prison instead. Ohio Governor John Kasich commuted the sentence of Raymond Tibbetts today. Tibbetts was convicted for the 1997 over-the-Rhine murders of his wife, Judith Crawford, and the couple's landlord, Fred Hicks. Tibbetts was scheduled to be executed earlier this year. That was put on hold after a former juror said the death penalty shouldn't have been recommended. Governor Kasich said in a statement today that his decision to commute Tibbetts' sentence was granted as a result of fundamental flaws in sentencing phase of his trial.
And just as another example of how we win by losing, when we went back to the parole board to answer the only question that was left, which is would it have made a difference? No member of the parole board changed their recommendation. The same number as the first time still said that they didn't recommend clemency for my client, which turned out, I think, to work in our favor because I think Governor Kasich recognized that like he really shouldn't give that much credence to this recommendation because they were unmoved by like the single and most important thing. So every once in a while, if you're going to lose, you want to lose in a way that really seems unreasonable because you might have a better chance of turning it around later on. So we did, luckily, and Mr. Tibbetts is serving a life sentence now. Okay, and then finally, the third area I was going to talk about that I alluded to is our lethal injection litigation. So, you know, a lot of states used to have the electric chair, but then most have moved to a form of lethal injection. And originally this was done kind of close to what you would see when you anesthetize pets. You would use an anesthesia, which blocks pain, puts you unconscious, and eventually puts you in a coma and kills you. But drug companies that make these medicines don't want them to be used to kill people. And so eventually the market dried up. Either the manufacturers stopped making the drugs, or they were from like the European Union, they stopped importing them. And so states for the past maybe decade or so have really been experimenting with other kinds of drugs. So Ohio switched to using midazolam instead of an anesthetic. Midazolam is just an anti-anxiety drug. It contains no pain blocking properties. And because of physiological interactions in the brain, it has what scientists call a ceiling effect. So the expert that I put on at the hearing said it's like taking a glass of water and filling it up. You can keep pouring more water in, but like it's just going to spill off of the edge. So the state's argument is like, oh, we're giving this massive overdose of this anti-anxiety drug, but the science is that really doesn't matter because once it connects to all the neurotransmitters in the brain, all that extra stuff isn't doing anything. It functions different than the anesthesia. So we presented a case that it was torturous, cruel, and unusual punishment under the 8th Amendment. And John Oliver actually did a segment a few years ago about lethal injection. And it's different in different states, but we'll play a little clip from that. And you'll see at one point up in the box on the screen, he shows a picture of the court opinion in our case. And he quotes from that, and where we had convinced the federal judge that it was torturous, basically, the state's method.
Of how lethal injections work. While the actual protocol varies from state to state, most administer drugs in 3 steps. First, they give an anesthetic to put the inmate to sleep. Second, a paralytic to stop the limbs from moving around. There's actually no medical reason for that. It's just for the benefit of the people watching so that they won't see a body flail or convulse as the third drug initiates cardiac arrest. And the really important thing to understand here is that the second and third drug in this procedure are both in their own ways horrifying. The third drug apparently feels like fire being poured into your veins. And even the second drug, the one, remember, that's only for the benefit of onlookers, is nightmarish if you are not completely knocked out.
If the inmate is not unconscious and the inmate receives a second drug that paralyzes the muscles, that is a horrible, horrible situation where you are awake, but you cannot move, you cannot breathe. So you have this sensation of suffocating, essentially. And you can't communicate to anybody that this is happening.
Yeah, you could be fully aware, feel like you're suffocating, but unable to move or communicate while fire is about to be injected into your veins. And this somehow qualifies as more humane than an electric chair, which seems pretty debatable at best. It's like saying which movie has sexier CGI characters, Zootopia or Monsters, Inc. I mean, probably more.
The segment is very good, but also very not safe for work. So that part was safe to share on this. So yeah, so that opinion was where the court had enjoined the state from performing lethal injections. And then here's what happened. The state appealed that to the appellate court, which is the Sixth Circuit Court of Appeals. And I argued that appeal and we won again, they affirmed it. And then they did a very unusual procedure called taking the case en banc. And that's Latin for the full court. And so normally in appeals, you have a 3-judge panel that decides. But like once or twice a year, the court might decide to have all the judges on the court hear a case. It's supposed to be because maybe there's a conflict, like one group of 3 judges decided one way and another group of 3 judges decided another, or it's of exceptional importance. Well, they took our case and they reversed our win by a single vote. And that single vote happened to be the judge that President Trump had just appointed to the Sixth Circuit after he won his election. So politics really play a role in this work. That's probably my least favorite part of it, because there's just sort of a cloud of suspicion that's unfairly held over our clients. And so unfortunately, several people were executed under that protocol, but we kept working and we ended up collecting new evidence. Now, in addition to the testimony we had from the scientists and the pharmacologists, we had autopsy results that showed pulmonary edema, which is kind of liquid and frothing in the lungs for people who had been executed, which meant basically they were drowning to death, but because they were paralyzed, nobody could tell. So then I gotta get my years straight, 2019, I think, we went back to court with that information, again convinced the federal judge that it was torturous, but he didn't grant us relief because the Supreme Court has said not only must inmates prove that a method of execution is cruel and unusual, they also have to offer their own alternative method that is better than the method the state wants to use. And let me tell you, going into prison and sitting down with your client and saying, all right, how do you want to die is not really a comfortable conversation. And in fact, many attorneys felt very ethically conflicted about whether they even could do this kind of work, coming up with assisting in a way to kill their client. And many clients refuse to allege alternatives, which effectively means they can't bring these kinds of claims. Anyway, we had alleged an alternative based on the state of Washington's dignity in death law, which is for, they don't call it, there's a new name for it and I can't remember it. It's not physician assisted suicide anymore because it's done like a person can kind of do it themselves. I can't remember the name, but anyway, it was based on the mix of drugs that they use there. Well, we lost in a technicality because the judge felt that we hadn't proved that the state of Ohio could import these drugs because we hadn't proved some small thing about licensing or something like that. Okay, we lose. But then Governor DeWine is elected to the governorship. And we were supposed to have the next execution in January, shortly after he took office. And he ended up saying, I don't care if they win or lose in court, I'm not going to stand watch over an execution that a federal judge has found is going to be torturous. So he suspended the executions. First said he wanted the prisons to come up with a more humane method with better drugs, eventually realized they couldn't do that. And the end result is that we are still, since that time, in an unofficial moratorium where the governor has said, if we want to start resuming executions, the legislature has to come up with a different method because lethal injection just isn't available to us. And thankfully, the General Assembly has not really shown much interest in doing that. And so for the last 2 years, we haven't had to deal with execution. So once again, we lost in court, but in the end, we ended up better than anyone would have done because we haven't had any executions. So that's sort of like a quick overview of the many different facets of what we do. And I don't know if there's any questions yet, but I'm happy to answer any of those, or if there's particular areas that you'd like to hear me talk more about, I'm happy to do that as well.
Thank you so much, Erin. For those who are participating, please feel free to turn your camera on to the extent that you feel comfortable doing so. And you can raise your hand. And if we see that, we will certainly call on you. It might be easier to go ahead and put your questions or comments in the chat, and I can help to curate those for Erin. And while you are doing that, please know that I've shared the links to the clips in the chat for you. Erin also provided several PDFs of articles that are exploring various aspects of the death penalty, and we will upload those to our undergraduate Blackboard so everybody has access to those. Thank you so much, Erin, for those resources.
While we're waiting for any questions or comments, I thought I would first of all give a shout out to the speech and debate forensics team at OU, which I credit with being the most important factor, I think, in my success in law school and as a lawyer. And that's where I met my husband and my best friends. And I always tell law students when I'm giving them advice about exams, because in law school, it's an entire semester worth of classes in a single 3 or 4 hour exam at the end. It determines your whole grade. And I always tell people, like, everybody has the same information. We've all read the same cases. We've all sat through the same lectures. And so what makes people stand out when it comes to grading the exams are people who can communicate effectively, who can analyze the information, put it in an organized way, using signpostings and previews and transitions, which is all stuff I learned to do in giving speeches, and not just learning to do it, but really refining it by practicing week after week, making small tweaks based on feedback. So it was just second nature for me when I had to do these exams to approach it in an appropriate way. So even if you can't join the team, I really encourage you to get as much writing experience as you can. And when I was at OU, something one of the professors said to me that I share all the time is that only when you get to the end of your paper or thesis or whatever it is that you're writing, do you know where to begin the second draft. Because the process of writing is as the author works through their thoughts and understandings, but you do not need to bring your reader, especially a decision maker you're trying to convince, along that process with you. So by the end, you figured out what you want to say, you start with that, and then you explain and support it. So there's a lot of complaints about poor writing in the legal profession, and I think it comes down to a lack of editing. That people are not disciplined or just are too busy, and they rush it off and they make their reader work through it with them instead of making it as palatable and easy to understand as they can.
Erin, we have a few questions for you, and I'll start with a question from Beck, one of our students here. You see firsthand that innocent people can be executed. Do you do any advocacy for justice reform in your free time?
So that's a great question. And I would just tweak it and say innocent people have been executed. I think that's uncontroversial and controvertible at that point, at this point. But I also am in a unique role because I cannot go to court and advocate for abolition. I'm representing a single client. And so, no, I am not like lobbying the General Assembly or things like that directly. However, I share my experiences with people who draw on them to show why. I mean, Elwood Jones, the client in the podcast, is a Black man convicted by an all-white jury of murdering a white woman. And data shows that that is the #1 type of wrongful conviction scenario. And in fact, our office, with the help of a lot of our law student externs, did a study collecting data in Hamilton County, which is where Cincinnati is, that showed that there was a statistically significant factor in the race of the victim and the race of the defendant. And you could predict that you're more likely to get the death, get convicted and get a death penalty, a death sentence because of those factors. So those kind of examples are used by the advocacy groups that are trying to, get reform in the system. And I tell like everyone I know about it too. So I guess in a personal way, I'm an advocate.
Thanks, Erin. And I will put in the chat an article that Erin shared about how advocating for the abolition of the death penalty actually values Black lives. So I will share that. While I do that, another question that has been shared by Amy. Erin, you conduct some seriously hard conversations with death row inmates. I'm wondering if there are any experiences at OU that could have prepared you for this.
I mean, #1, this is what I say. I might not literally be able to do a single thing in court or even outside of court to get a win for my client. The facts are bad, the law is bad. That's the reality. Politics, decision makers. But what I can do, no matter what the case is that I can, maybe for the first time in my client's life, be someone who acknowledges and recognizes their humanity as a person and not just a label. And so, I think when I first took this job, people, I don't know what they imagine going to death row is like. People are like, aren't you afraid, to go to prison? Like picturing, like from the movies, like Hannibal Lecter or something like that. And like, not at all. I really enjoy visiting my clients. They're mostly, kind of sad people who've had really tough lives. I'm not afraid of any of them. I do have some challenging clients, but that's almost always due to, mental illness or, reaction to some kind of trauma or anxiety. So, yeah, I mean, I guess the biggest thing with dealing with my clients is that like, they're just people, I'm like, just like I would, deal with my friends. But combined with, an empathetic understanding of not only where they come from, but like what they're going through. This last 2 years has been so hard on my clients. For the longest time, visiting was completely shut down at the prison. I mean, they're just petri dishes. There were COVID outbreaks on death row throughout the years. I had a client who ended up at OSU on oxygen. I was, it was a really scary time. And so I just try to remember that, because as hard as it is on us, it's been like even harder on them. And I have another innocent client who I didn't have time to talk about today, but we're in the midst of sort of proving his innocence. And it's one of these junk science cases where it actually wasn't a murder at all. It was just an accidental fall down the stairs. But there's this whole junk science area called shaken baby syndrome and inducive head trauma. And so at court, the prosecutor said like this injury had to come from abuse. It couldn't come from an accident, which is totally bummed. So anyway, we have gotten what's called discovery, which is the federal court allows us to question people and get records like from the hospital or other places that we couldn't get without court order. And that has been very good because we've been finding helpful information. And I can have a private confidential attorney call with my client, but anything else, emails or phone calls or video chats out of prison, those are all recorded. And so I would tell this good news to my client, and then like he can't do anything with it. He can't tell other inmates because it's confidential, and that would violate that privilege. He can't even tell his family on the phone because it's recorded, and that would violate confidentiality. And normally you could tell them when they visited, but nobody could visit. And so, he was going kind of stir crazy. And I understand why. And I just really, we ended up putting together like some mindfulness resources for him. And just trying to really understand where he's coming from and say, I know this is really tough, and I can't fix the pandemic or visiting, but let's see if we can, come up with this way to cope with it for now.
Erin, what advice would you have for students who want to pursue a career in the law, are interested in going to law school, envision themselves doing something similar to you?
Yeah, don't do what I did, which is kind of going blind. And I'm just very lucky that it all worked out. There's so much information you can find out beforehand. And my parents aren't lawyers, and I didn't know about so many things. This law review that Amy mentioned is a really big honor. I didn't know anything about that. And then I did something called a clerkship, which is working for a judge, a federal judge in their chambers, and absolutely loved it. And that's also a pretty prestigious position. Didn't know anything about that. So I would, talk to lawyers and law students. OU doesn't have a law school, but OSU does, and you can come up and visit. I know OU professors have put me in contact before with undergrads who have come up to do a visit at Ohio State. And, one time I was judging a moot court competition. And so that student came to that and got to watch it with me. And, I got to talk to her about what it's like. So just find out all that you can about what it's like. And, if it's something you'll enjoy, because it's totally different than undergrad. And it was very different for me because I was very spoiled by the honors tutorial college, in that I had very specialized classes designed around what I wanted to study. And for the first time in my life in law school, I was in a class with 100 other people, and we were all learning the same thing. And it was a struggle for me. So, just having information going in, but then also I would do a lot more to try and figure out what kind of law you want to do. Now, if you don't know, I think it's okay. I never knew. I used to say this all the time. I just try to be open to opportunities. As I mentioned, the forensics team is the biggest part of my life, and I didn't even know it existed before I went to OU. So you could try to plan something out, and you would have totally missed it. So be open to these opportunities. I didn't even care about criminal law in law school. I didn't even take the criminal procedure course, which is, people think that's crazy when they find out what I do now. Because I just was it's okay, but it didn't really interest me. It was only when I started practicing that I started being drawn to that. So, it's not like you have to have everything planned out, but if you do know what you want to do, then there's some practical decisions to make. And if you want to go into public interest, into, an area that is not the type of 6-figure salary you're going to be making in a law firm, then you don't need to go to a top tier law school and go into debt when that's not going to matter. It's just going to saddle you with debt and kind of limit your choices. So you want to find out from people. There are certain schools that have clinics and special classes. Ohio State now has an immigration clinic, and people are able to represent, students are able to represent people in asylum work. The University of Cincinnati has the Ohio Innocence Project located there, and so students get to work on that. So, I would just I never thought that I wasted time by talking to a lawyer when I was going through school, because you always learn something. Maybe you learn you don't want to do something, which is sometimes the most valuable thing you can learn. So I would try to get information about it beforehand. There's tons of alumni, who are lawyers, and your professors can connect you with them. They have with me, or you can just call up a law school and say, like, I'd like to do a student visit, and they'll pair you up with someone. So probably like in anything in life, get more information, but I didn't even know where to start to get information. So that's the key, is ask someone who can tell you where to go.
Thanks for your honesty, Erin, and your emphasis on being open to experiences that you could not have anticipated, right? In the past they lead you on. We have another question from Mackenzie. Due to the emotional severity of your job, let me pull this back up because another question came in. Due to the emotional severity of your job, what methods have you found beneficial for creating balance between your personal and professional life?
Well, first of all, I'm probably not as good at this as I should be. But that's because like my job is more than just a job for me. And I think I would be very unhappy if I just did a job. I'm fortunate that my husband, who I mentioned I met on the speech team, is also an attorney. He started as a prosecutor, but now he's a criminal defense attorney like me, but he is like at the very beginning of the process at the trial level. So we both understand each other's jobs really well.
My ears are burning.
There's Rob.
Hello.
Rob, there's Jerry.
Oh, hi, Dr. Miller. Sorry, I was just walking by.
Okay.
Enjoy.
So that really helps. Like, we've always been the kind of people who like share with each other what we're working on. So I'm not like, I want to leave at the office and then not think about it. Like, I'm going to be thinking about it anyway. So it helps to have someone who understands that. I don't know if this is exactly the right answer, but going in, I knew like that this was going to be difficult work. And there's a phrase that I heard at a conference once that is something I think like emergency room and critical care personnel say, which is that when a patient arrives, he's already dead. Meaning like you really can't make it worse than it already is, because things have really gone wrong by the time they get to you. And that's a bit freeing because it gives you the opportunity to be like, well, I'll just try something. I don't know if it's going to work, but I don't have to be like so afraid because, I'm not going to make it worse, most likely. So, I think that sort of helps me have what's the right word? Like the inner peace or the sanity to be able to do this work. And again, this is like another forensic lesson I learned. In speech, you are judged throughout several preliminary rounds, and then the final, sometimes there's 3 judges or 5s, and you're ranked like 1 through 6. And the same speech can be named the best speech in the round by one person and the worst speech in the round by another. And that's out of your control, right? And so all I can do is my best, be satisfied with my work and put it out there. But once it's out there, which decision maker I get, like what's going on in like the political climate that is making it palatable or not. I mean, for Mr. Tibbetts to get clemency for Governor Kasich, I mean, something that worked on our side was that Kasich was setting himself up as being sort of like the anti-Trump conservative politician. And so we were able to appeal to his sense of like faith in our institutions and like the system like didn't work here. Like there's a failure, you need to correct it. And if another governor was there and there was different president, I don't know how it would work out. There's just so many things you can't control. So I think I find balance by coming to a place where I am satisfied with what I have done so that I then can allow myself a break and to have balance, and also to recognize like, I don't know, like self-care is sort of part of your job too, because if you don't do that, you're not going to be as good as an advocate as you could be. So, it's not like a luxury, it's like an obligation that you have, just like an obligation to like eat and sleep and remain healthy. So I try to reframe it like that, but it gets hard, especially during the last 2 years when we've had a lot more work than usual.
Erin, I would love to circle back to something that you shared earlier about how prosecutors oftentimes want to start the story with the crime. And from your perspective, we need to start the story, especially in mitigation. We need to start the story earlier with what happened to individuals that might have led to that. So it really speaks to the importance of storytelling, where we punctuate stories. I'm wondering if you can just speak to the role of storytelling in the work that you do.
Yeah, I mean, we actually have like specific conferences about narrative technique and storytelling. I'll, before we end, I'll send a link to a particular website. This attorney's name is Doug, and he used to have my job in Arizona, but he also has a filmmaking background. And so now he's like a consultant that makes videos for usually for sentencing videos for not my kind of work, but sort of like regular trial work in federal court, which is like drugs and guns and immigration violations and that kind of thing. And so he's all about, you know, like the hero's journey. And he has this presentation about how, like, you know, the whole point is to get your decision maker to empathize with the person you have, you know, with your client as a person, so that it is like uncomfortable for him. That's how he puts it. Like, you want to make the judge uncomfortable because they confront like this situation where, you know, people's, you know, lives and liberty and everything is at risk. And so to do that, you have to learn how to make that connection. And he has so many cool techniques for that. Like, he tries to find like a special like skill or something that the client is really good at. Like, one example he gave was, I think this was maybe like a deportation violation. Someone had been deported to Mexico and then crossed the border again. But this guy in his home country was like a incredible tailor. And so they filmed him like with the scissors on fabric and doing all this detail work, because his point is you really need to like showcase someone doing something that they're very proficient at. Another client like could play the piano, because people really connect to that on a very like fundamental level. And I think it helps, you know, you see value in people and maybe yourself in someone. So yeah, I mean, there's just like so many lessons from great literature and films and plays that we use. And for Mr. Tibbets's case, we put together a long video for his clemency hearing, about like half an hour. But then we broke it up into different topics that are just a few minutes long. Like one about, you know, his childhood and the abuse and neglect he suffered. Another about the substance abuse and how the opioids, you know, came into play. Another about sort of like who he is now and what he offers to people. He's got hooked up with this prison ministry at a church, and he writes to other inmates and offers support. And we had his pastor talk about why he's, you know, his life has value and he's worthy of forgiveness. So yeah, I mean, judges get like stacks and stacks of briefs, and they're boring, and they're in very inaccessible language, but like everybody, that's like the human experience. Everyone connects to narrative and to storytelling. And that's what you've got to do to get your decision makers like engaged and involved.
And uncomfortable. It's an interesting juxtaposition, right? That discomfort can be connected to empathy.
Right, because otherwise it's just too easy to sort of like write it off. But like, if you actually are connected to this person and you realize like, I am, you know, I have like power over his life. And this isn't just like a number on a piece of paper. Like, this is a, you know, a real full three-dimensional person. We want it to be difficult, you know, for the decision maker to confront what they should do.
Yeah. Erin, thank you for joining us tonight. Thank you for representing Ohio Comms and what it means to be a Bobcat, and for the public advocacy work that you do in really high stakes situations. We're honored to call you one of our own.
Oh, thank you. Thank you for inviting me.
Let's give a virtual round of applause to Erin. As I shared before, we will upload resources from Erin to our undergraduate Blackboard site so that people can access those. And Erin, we welcome you back face to face as soon as
Yeah, I'd love that.